In the spirit of reconciliation, we'd first like to acknowledge that Hearsay podcast is recorded on Treaty 7 territory. We'd like to take this opportunity to acknowledge the traditional territories of the people of the Treaty 7 region in southern Alberta, which includes the Blackfoot Confederacy, comprising the Siksika, Piikani, and Kainai First Nations, the Tsuut'ina First Nation, and the Stoney Nakoda, including the Chiniki, Bearspaw, and Goodstoney First Nations. The City of Calgary is also home to the Métis Nation of Alberta, Districts 5 and 6. I'd also like to note that the University of Calgary is situated on land adjacent to where the Bow River meets the Elbow River, and where the traditional Blackfoot name of this place is Mohkinstsis, which we now call the City of Calgary. Hello, and welcome back to the Hearsay podcast, a joint project between Pro Bono Students Canada, University of Calgary Chapter, and CJSW 90.9 FM. This is a podcast where University of Calgary law students discuss a variety of legal topics with a plethora of professionals in the field. We'd like to emphasize that the information you hear today is legal information and not legal advice, as we are law students and not lawyers. This podcast is purely for informational purposes. If you do require legal advice, please consult a lawyer, as there is no substitute for a professional. My name's Josh Namias, and today we'll be speaking with Professor Martin Olszynski, an associate professor and chair in energy, resources, and sustainability at the University of Calgary, Faculty of Law. In a post on AB Log, Professor Olszynski and several other University of Calgary law professors co-authored a compelling analysis of Mathur and Ontario, one of the most significant climate-related charter cases in Canadian history. Today, he joins us to break down this landmark decision at the Ontario Court of Appeal and discuss its far-reaching implications for climate policy, constitutional law, and the future of environmental litigation in Canada. It's a particularly relevant case now, with all the discussions surrounding new pipeline and energy projects in the country. Great to have you here, Professor.
Thanks for having me on.
Now, before diving into Mathur and Ontario, can you tell us a bit about your background and your work at the University of Calgary Faculty of Law, particularly in energy resources and sustainability?
Sure. So I graduated from law school almost 20 years ago now. And at that time, moved to Ottawa. I clerked with the Federal Court of Appeal, after which I joined the Federal Department of Justice, where I worked in the Legal Services Unit at Fisheries and Oceans Canada. And so my work at what we referred to back then and still now as DFO was really in the sort of major project review and habitat protection sort of program. So I was doing environmental assessment work, mining reviews, mining effluent regulations, those kinds of things. So working essentially on big projects at the federal level. And after doing that for about 6 years, had actually always intended to practice or to come back to academia. It was a mentor of mine, my former judge, who sort of suggested that I would benefit from some practical experience before making my way back into the academic world. And so that I did that and was ready to go, jump back in. And there happened to be a position and availability here at the University of Calgary Faculty of Law. And my wife and I are both from Western Canada, and our family's all in Western Canada. And so we decided to make our way home. And so we've been here for the last 13 years or so, 12, 13 years. At the University of Calgary, in terms of my research agenda over the past decade or so, I guess, I think it is safe to say it was very much a progression from my practice experience. And so I've always been very interested. I think sometimes I kind of think of myself as kind of doing the plumbing work in environmental law and policy, in the sense that I've not spent as much time in the sort of theoretical world and even the doctrinal world. I tend to really focus on regulatory regimes and their practical application and how things play out and how things are working, sort of looking under the hood, as it were. We always hear in Canada that we have this world-class environmental standards. We talk a lot about, at the same time also, that we could go faster, the idea of efficiency, and I think you picked up on that well. So I've spent a lot of my time sort of being like, well, actually, how are things going? How do things look? And unfortunately, and maybe not totally surprisingly, that when you look at our environmental laws and you look at the regulatory regimes that are in place, there's a lot of things that are going sideways. There's a lot of there's a lot of room for things to kind of go off the rails. We think that they work a certain way. I guess we say, there's a general saying that there's there's a difference between the law in the books and the law in practice. In environmental law, academics and scholars before me have said that that's more like a chasm, that difference in terms of practice and then or on the books and in practice. And in Canada, one of my mentors as well has sort of said, well, it's actually like the Grand Canyon. In terms of that difference. So I have spent time in that space. That has been a focus of mine, looking at environmental existing regimes and how they're working, empirical legal work, that kind of stuff. And then also, and maybe as a dovetail into this, interested in climate policy and law, interested in climate litigation. And so then really the Mathur case is really just the one branch of really like numerous sort of litigation fronts in the climate space.
Really looking forward to talking more about regulatory frameworks, and I think that segues very well into our discussion. Can you give us a little bit of background, facts, and issues discussed by the Ontario Court of Appeal and Mathur in Ontario, and why you decided to co-write the article?
Yeah, so the Mathur litigation has its roots in a decision by the current Premier, Doug Ford, shortly after he came to power in the late 2000 teens, like 17 or so, where the previous Liberal Ontario government had enacted some fairly robust climate laws and policies, a cap and trade system essentially, and was really driving towards emissions reductions. And actually Ontario had done a lot of heavy lifting early on by retiring some of its coal plants and had done some good work and had seen some real gains. But when the Ford government came into power, essentially they decided that they were going to water down that law, right? And they were going to weaken it. There was in a sense, a target for reducing emissions in the legislation. They took that out and instead said that they would set it on a regular basis. And then when they set that target, they actually, like I said, they weakened it to a fair degree. It became much less robust. And so really that triggered, I think, the concern from the environmental community in Ontario and in particular this idea that, while we've all begun to experience the effects of climate change, as these effects become more acute, as this problem exacerbates, as there are more and more emissions going forward, that it really is actually the young people of today, who are going to really suffer those consequences, right? Because more of their life will be in this kind of climate change reality. Similarly, we might say that, so there's that angle exactly of that. And then, the idea that that it affects youth differently than maybe other groups in our society. But that fundamentally it really does affect and puts at risk all of our charter rights to life, liberty, and security of the person. And so a group of youth throughout Ontario were sort of identified themselves and came forward to launch a charter challenge then to this decision by the Ford government. And at this point, there had already been a little bit of litigation in this space in Quebec, but that litigation ended up sort of like being dismissed very early on. And then there was already some discussion, some movement towards a federal lawsuit, so a charter-based climate lawsuit against the federal government. And there had been some academic writing, and one of the concerns in the space is always that, is this really something that the courts are cut out to do? Is it justiciable, right? That's the doctrine that we talk about, justiciability. And I think in Ontario, one of the things that was really attractive in this instance was that it wasn't just a question of sort of, trying to cobble together a series of policies and laws and whatever and argue that all of it together essentially was infringing on these charter rights, but rather there was a specific decision, a specific change in law. And so the applicants were able to sort of challenge that and say this decision to weaken, to soften essentially the rigor of the targets under Ontario's climate legislation, that it violated the applicants' Section 7 rights to life, liberty, and security of the person, and also that it violated their equality rights under Section 15. So the idea, again, that, for instance, youth might be more discriminated by these policies than the rest, like someone like myself, for instance, who's properly into midlife, or someone even older. We've seen in other lawsuits also Indigenous peoples have made the point that they also will suffer in a different way and more harshly, in part because they are, so much of their culture is tied to the land and activities on the land, rights. So that really set the stage. That's the factual matrix for this litigation. Yeah.
Now, you mentioned this in a little bit about the background and the factual matrix of the case. Can you go into a little bit more detail and how the applicants argued that their Section 7 and Section 15 charter rights were violated?
Yeah, so, I mean, the idea here is that climate change doesn't just happen. There's nothing inevitable about climate change. Climate change is, at the end of the day, actually the result of a decision by successive governments over time to authorize greenhouse gas emitting industrial activity, energy sources, and all those kinds of things. And so that, in that context, that's what we really need, right? Like, so as opposed to, and this may be a good moment to step back and sort of contextualize this litigation. So there's climate litigation happening all over the world right now. In almost every sort of like developed country, usually there are stakeholders. Sometimes it's public interest organizations, sometimes it's private landowners who are, suing governments, suing various parties. They're suing industry sometimes they're suing governments. And so it's good to keep that in mind. So like there's a difference, so you might sue a corporation, for instance, for harm suffered, and then we're applying tort law basically, and and we're trying to argue either maybe negligence or we're arguing nuisance, right? Then there's the category of cases that are against government. And in that context, I think there's really two bins. There's one, which is like the classic world of judicial review, where governments are making decisions about projects, about approving certain kinds of development activity, and the idea is that they're not paying attention to climate change. That they should do more about climate change, that their decisions should reflect the urgency and the problem of climate change. So that's one category, and we've seen a lot of those, and those are kind of standard too. So then in Canada, though, because we have a charter and because we have these charter rights, there's this idea that we might also be able to compel governments to take action because they have this special obligation to not violate our Section 7 and our Section 15 rights. And we'll get into the weeds here a little bit. There's some interesting theories and differences between this kind of claim and other claims, for instance, maybe to freedom of expression or to the right to equality, that get sort of like, that's really why these cases have taken these weird twists and turns. But the basic idea is just that that climate change isn't just some inevitable force, and it's not just something that private interests are doing on their own, but rather there is a government. The government is a player in the space. It's an important player, and to that extent, it can do better, and it should do better. And in the absence of doing better, it is putting at risk those charter rights.
It looks like the Ontario Superior Court's original ruling categorized Mathur as a positive rights case, but the Ontario Court of Appeal disagreed.
Yeah, I mean, they disagreed or they sort of sidestepped the issue, I think is kind of the best way to think about it. So let's back up a little bit. This decision is the third sort of judicial decision in Mathur so far, right? So at first what happened is when the application was filed, the Ontario government sought to have it dismissed out of hand, right? They filed what's called a motion to strike. They sort of, and this is when you walk into court and you say, like even if we assume all the facts are true, there's no claim here. The law does not recognize this claim. And as part of it was this issue exactly of what are we talking about here? This is unprecedented. We don't have a precedent for these kind of charter claims to be made. And the Superior Court, recognizing that it has to take a sort of like err on the side of caution here, said, I won't strike the claim. We're going to go forward to the merits. And so then it went to the merits. And on that front, so in a sense, the applicants won that first round, but then they lost on the merits. And exactly as you say, what happened in that decision was that the Ontario Superior Court said, this is not just about, you're not saying that government is interfering with a right. So this is the idea of this negative conception of rights under the Charter, right? So we say that if I want to say something and I am censored from saying the thing, then that, and by government, then I can say that they are interfering with my right. I have the right to free expression. I have the right to say what I need to say. And if the government interferes with that, they are interfering with that right. And that's not allowed. But we, in the same breath, we say the government has no obligation to provide me with a soapbox. They don't have to facilitate my speech. right? It's not, I don't have any positive claim to being paid to say what I want to say, right? It's that the government won't interfere, right? And so that's what we say when we talk about a negative conception of rights. And that distinction, I think, and so then again, as opposed to a positive, this idea of a claim to a benefit, that government has to give us something. And then traditionally, our charter has been interpreted as protecting negative rights, not positive rights. And so, but not without some exception. Right. And so there are so the one case where it very clearly failed is in the context of welfare, right? The provision of some kind of income assistance. At one point there was a case that went to Supreme Court where the argument was that, the charter guarantees without this welfare, without income assistance, these individuals' life, liberty, and security in person is at risk. And the court said, no, we're not going there yet. This is not the case. Maybe someday, but not right now. There are other cases where the question of whether or not it's positive or negative has been sort of blurred. So, for instance, in Quebec, there's a famous case, I think it's Chaouli, involving restrictions on private healthcare, right? And in that case, the idea was, in a sense, we don't have a right to healthcare, but once the government entered into that field, the court said it had to do so in a way that still protected those rights. And so that kind of provides the opening for the discussion around negative and positive rights. At the Ontario Superior Court, at first instance, the Superior Court said, everything about what you're saying to me, you're saying the government's not doing enough. You're saying that they need to do more. You're saying that this target isn't robust enough to prevent climate change, to prevent risks to your Section 7 rights, to your Section 15 rights. What you're saying is that that there's a positive claim for the government to do something. Now, and ultimately the court, that's what they agreed. That's what the court at the first instance sort of said, and said that even in that instance, if it was prepared to say that those rights were engaged and that they existed, the other part of Section 7 in particular says that the right to not be deprived thereof except for in accordance with the principles of fundamental justice. And the court said, I can't see how that would seem to save the day here. There's no, you haven't pointed out to any kind of breach of any principle of fundamental justice that would make the government have to provide these rights. That then goes to the Ontario Court of Appeal, and the Ontario Court of Appeal basically says, it doesn't really matter. We don't need to have this conversation actually about whether it's a positive rights or negative rights. Here's the thing. Government has legislated. Legislation in Canada has to conform to the Charter. The Charter is a constitutional law. And therefore, the question isn't whether or not these are positive or negative rights, but rather, does this legislation conform to the Charter? Is it consistent with the Charter? And so in that context, if the parties want to make an argument that, no, this new watered-down legislation doesn't conform to the Charter, then they make that argument on its that way, basically, And so then in that context, and this is where I wish that my co-authors who are much more Charter expert than myself would chime in. But the idea is that in this context, the argument might be, instead of sort of focusing on whether it's robust enough or not, we might think about things like, is it arbitrary? Is there a rational connection, right? The things that we usually expect governments to do when we're thinking about infringing on charter rights, it's not that they can't, right? When we think about the Oakes test, whether it's reasonable, demonstrably justified in a free and democratic society. So then it becomes really a question of just putting the Ontario government and any government that is in this space, putting them to the task of showing their math, right? Basically saying, show us how, in light of the charter risks that appear to be at stake here, right to life, liberty, security of the person, and we can talk a bit about that front end, I think, as well, a bit more. But in light of that, in light of the Section 15 rights, show us how you've settled on this policy. And the idea, I think, is that, governments can act to varying degrees of rationality in Canada on various policies. But when it comes to charter-protected rights, the Charter, in a sense, insists on a certain level of rationality and robustness and rigor. And so that then becomes, in a sense, the argument. Show us that these targets, this new cap, show us that you've done the math to make sure that this is really, that you've balanced everything out and that you recognize the severity of the potential consequences. And so the Ontario Court of Appeal didn't make a decision. It remitted the matter back down for a new trial.
Is there a fear that politicians could repeal this type of legislation in order to ensure that there's no obligation for them, no constitutional obligation for them or charter obligation for them to keep emissions at a certain level?
Yeah, I mean, I think, that risk does exist. There's always, of course, the risk in the background also that if they see that they might face an adverse charter ruling, that they might invoke the notwithstanding clause, right? So we do have a provision in the charter which has apparently become more popular in recent times. Certainly during my day, it was almost unprecedented in its use, but we've seen its use increase significantly. But I'll tell you why I think while there's a risk there, there's also a benefit. And I think it's that to some extent, and this actually goes back to our intro here. And when I was talking about sort of my work around sort of trying to figure out how actually effective are our environmental laws. It is very easy in a democratic society such as ours, where there are multiple issues going on all the time, and for voters in particular who are concerned about various issues, right? It's very hard to sort of figure out which issues are going to be top of mind. There's been a time that the climate and environmental protection were amongst the top issues on voters' minds. Currently, I think everyone would agree that economic resilience and sovereignty are really important. So in that space, of course, and that's all good and fine. But in that space, it's all too easy for governments to fake it, basically, to pretend like they're passing laws to deal with a problem, recognizing that the average voter doesn't have the time to really get into the nuance of whether or not this law or that law is effective. Is it actually going to do anything, right? And in a sense, politicians use that, I think, to obfuscate the situation and sort of say, no, look, we're doing stuff. Don't worry about it. We're good. And so in a sense, if it's the case that by having a climate law, we say that the charter requires those climate laws to be bona fide, to be sincere, right? And for the government to be transparent about the trade-offs that it's making and whether or not it understands that its laws will do very little as opposed to doing a lot. And that in the face of that risk, they might just pull back altogether. Well, then I think in a sense, we might say from a democratic accountability perspective, that's better because it's clearer, right? Then we can sort of say we have some sense that when dealing, and of course, not all legislation is going to sort of like engage the charter. But when we're talking about when those charter risks are at stake, when Section 17.7 rights are at stake or 15, then I think the argument is from one side anyways, it's better if you don't do anything and deal and take that on the chin politically, right? Because then we can all have a very clear, the political accountabilities are more clear. You're not doing anything. Why aren't you doing anything? Well, we're not prepared to do anything that's meaningful. Okay, well, that's good. And then we can move on and sort of say, well, what about you to the other parties or whatever? And so my view is that that's actually at least a compelling counter argument and maybe even outweighs the risks of some governments doing nothing. I do think also then that, notwithstanding the current moment, when it feels like everything that's, like any attempt to actually do something good on the environment or in human rights or in labor or anything else is under attack, we're sort of dealing with a political climate globally right now that seems to be very antagonistic, very individualistic, very sort of like set against any kind of collective effort. That being said, I think it would be very hard for any jurisdiction right now to entirely pull away from the climate space, right? And so in addition to those sort of political accountability issues that I think affect the calculus domestically, there's a reality that it would be hard, I think, for any given jurisdiction right now, in light of everything that the other jurisdictions are doing, to sort of totally pull back. So they'll be kept in the game, I think, to some degree. And then again, you can leverage this kind of ruling and these kinds of principles to force governments, legislatures, to make sure that the laws that they're passing actually are going to work in some way, and or at least that they're transparent about the extent to which they're going to work.
So procedurally, you mentioned this, the case is going back down to the Superior Court. Where do you see the case going from here? Is there a possibility this could go up to the Supreme Court of Canada?
Well, so actually it's interesting. So actually Ontario has appealed the Ontario Court of Appeals decision. So while technically the case has been remitted back to the Superior Court, currently before the Supreme Court is a decision about whether or not it's going to hear an appeal of the Court of Appeals decision. And in that context, it's my understanding that EcoJustice, actually the lawyers for the applicants here, have also filed a cross appeal. And so in a sense, Ontario, the appeal, to my understanding, I haven't seen it, but the idea is that they want to, of course, have the Supreme Court say that the Ontario Court of Appeal got it wrong, right? And then that the Charter is not engaged in this case and those kinds of things. They'll probably rehash all of the arguments that they've made sort of up till now, which includes arguments like this isn't justiciable, the charter rights aren't engaged. And I think that counsel for the applicants says actually the cross appeal says not only was the Ontario Court of Appeal right, but instead of sending this down, actually let's just go and do this right now. And sort of asking the Supreme Court of Canada to rule on the substantive charter issues. So it might go to the Supreme Court much faster, actually, than anyone anticipated.
Ontario did argue in this case that, they contribute a small fraction of global emissions. Why do you think the court rejected those arguments?
Yeah, so that's great. And I think, we really saw, in a sense, it's like this kind of litigation, generally climate litigation, has really been going on for roughly 15 years now, actually, 15 to 20 years, if we think about some of the early lawsuits actually in the United States. And I think there's really, judges in this context are really faced with two options. The one option is, and this was the one that was dominant, I think, in the early litigation, was to say exactly that look, this one jurisdiction, this one regulator, whatever, we might say here that you're not doing enough, but that's just a drop in the bucket that, frankly, this is a global problem and therefore it is a problem that has to be solved in the international and sort of national and international sort of arena through politics, not in the courts. Of course, when you do that, then you create no urgency for the political class to do anything, right? And so then the alternative, and this is what we saw the Supreme Court take up, I think, this approach in the GGPPA reference, which is like a totally different case, but about climate change, right, about carbon pricing in Canada. And then we've seen other courts and other jurisdictions say the same thing, which is to say that, of course, any one individual source of emissions, even a province, in that case, when there was a carbon price reference, this was about whether or not the federal or provincial governments have jurisdiction here, right? The provinces made the exact same argument. They said, we are a drop in the bucket. If Canada is 1.5% of global emissions, then each province is less than 1%, a fraction of a percent. So therefore, nothing changes if we do or don't do anything. And then, the Supreme Court's response, the Chief Justice said, well, if you do that, though, then no one will ever be liable or ever have to sort of be called to account. And he said, that can't possibly be the case. So I think when we look at the question of significance that we're talking about essentially now is a question of significance, I think the courts have basically said, we recognize that this is a collective global action problem. And so maybe we can't go after, we're not going to go after every leaf blower and lawnmower. But when we're talking about major industrial facilities, and certainly when we're talking about provinces, and I think at this point it's worth pointing out that Canada is a top 10 emitter globally, right? So that means that there are 190, roughly countries who emit less than we do. And so recognizing that, if we don't have to do anything, if all those emissions are insignificant, then all those other emissions are insignificant, and this is cooked, right? It'll never be dealt with. So I think in the GGPA reference, and in this case, the court made a finding, it was prepared to accept that it would look at it in a relative term on the basis of national emissions, in a sense, to say these are significant from the perspective of Canada's emissions, and that's enough in order to engage both the charter rights in this context, recognizing that other countries will have to do other things and all that, but saying these are significant enough to engage this charter analysis.
Now, looking at in the big Canadian picture, we're in a very, of course, interesting times with tariffs, and we've got a lot of politicians indicating that there's a need for moving faster on energy projects or building up, doing some Canada building. Is there a risk that the decision Mathur and climate priorities more generally could be discarded as a result of some of the things going on? And how do you see things playing out?
Yeah, so that's a great question too, and so I think there's no doubt that environmental considerations, climate considerations appear to have taken a back seat in the current sort of frankly, like distress and concern over, U.S. aggression towards Canada, antagonism towards Canada, right? The tariffs, but not just the tariffs, of course, talking about annexation. So everyone seems, it's almost like Maslow's hierarchy, right? Like it's hard to think about things like the environment and climate change when you have more immediate concerns. You have people Googling about whether or not they're going to join the reserves or whether we should have a civilian defense corps, and those kinds of things. And so I think that's perfectly normal and natural. And I'm right there with everybody else in having those concerns and sort of preoccupations. But what I will say, and actually it's interesting, so myself and a colleague from out east, we just recently penned an op-ed that I think will be up later this week. And the basic point that we're trying to make there is there's no such thing as a free lunch, right? These are just common sense. As a matter of common sense, we know that there's no such thing. And so, for instance, in the context of climate change, there's no question that someone will pay for it. The question is who and when, right? We know when we look at the science of climate change, we've been warned for a long time that it's going to exacerbate extreme weather, and that as a consequence, we will be paying more in terms of, mitigating those effects and having to adapt to these different sort of like climatic regimes. The fires in California recently, right, were record breaking. I think they cost something like over $130 billion in losses. In Canada, we had the Fort McMurray fire. We had just like record fire seasons in the past while. Shortly after one, heat dome, the heat dome in BC from a couple of years ago, which burned the town of Lytton down. Then we had torrential rains, essentially what's called an atmospheric river, which wiped out the highway. And those were all costs too. So we are already experiencing the costs of climate change. We're already paying for those things. And so I think it is really important, like for Canadians, especially now that we're in an election at the federal level and we're going to have different parties presenting different visions of how to respond to this crisis. I do think it's important for all of us to remember that there is no such thing as a free lunch. And also sort of another sort of basic, principle of common sense is that an ounce of prevention is worth a pound of cure. So while I support and understand the need to shore up our economy, ensure that our economy is robust and resilient, that it can withstand tariffs from our neighbors, that we might be able to diversify our trade, that doesn't mean that we should suddenly dismantle all of our regulatory regimes. It doesn't mean that we should totally cast aside any concern about climate change and reducing our emissions. I think we can walk and chew gum at the same time. I think we have to be strategic. I think we definitely have to think, and I think that that's going to be the challenge for us in Canada at a national level, is finding that sweet spot, figuring out, accepting, I think, and again, I think everybody is in a situation where if you're not reassessing your prior assumptions, then you're not paying attention. I think everybody has to do that. But at the same time, I'm very wary of interests who are pushing the exact same policy prescriptions they've been pushing for the last 5 years, suddenly now saying, well, yes, of course, we need to do X, Y, and Z, which we've always wanted, but we have to do it now because we have to deal with Trump. So we'll have to see. At the end of the day, this is sort of like outside my wheelhouse, the world of politics and that kind of stuff. But it does seem to, but I think you're absolutely right. Like, certainly the current moment puts a lot of these concerns on the back burner in a sense. And so I think it will require thoughtful leaders, both in terms of political leaders, but also our economic sort of like leadership, the pundit class, to really sort of help steer the ship towards a sort of a middle ground that recognizes that we have to do these things, but we don't have to, in a sense, when we think about what makes Canada the envy of the world, it is our air, land, and water, right? These are the things that actually, and in a large part have always been like an integral part of our Canadian identity. And so liquidating them in a rush, in a race to the bottom with our southern neighbor, because that's suddenly what they've decided to do, I hope we don't go down that road. And then once the dust settles a bit in the next couple of years, hopefully, once things once there's that realignment, then we can, and things settle, then we can continue with the work of trying to reduce those emissions, at which point this kind of litigation and the charter-based climate litigation in Saskatchewan and the federal litigation, all of which are still moving through the courts and changing and growing and evolving, then we'll be able to sort of come back to that place and make sure that what we're doing is consistent with those really important values, like the values that underpin the Charter.
Well, we'll leave on that note. Thank you so much, Professor Olszynski, for joining us today and offering your insights on Mathur in Ontario and its broader significance for Canadian climate and constitutional law.
You're very welcome.
That concludes part 1 of our interview with Professor Martin Olszynski. You are listening to the Hearsay podcast. We're proud to present you with legal information, but please remember that this is legal information, not legal advice. If you require legal advice, please consult a lawyer. The Hearsay podcast is a joint project between CJSW 90.9 FM and Pro Bono Students Canada University of Calgary chapter. If you'd like to hear more podcasts like this, the Hearsay podcast can be found on Google Podcasts, Apple Music, Spotify, or wherever you get your podcasts. Thank you for listening, and we'll see you next time.